नमस्कार, मैं कमलेश शर्मा आप सभी का के न्यूज ग्रुप में स्वागत करता हूं।
ऑल इंडिया मतलब इंडियन रेलवेज।
And for the PRO, there were 23 posts created. Senior PRO के लिए there were only 8 posts. And for the chief PRO, there were 9 posts, Your Lordship. The rules were created in 1982, Your Lordship. Soon after the rules were created, in 1989, there was an administrative instruction. 1982 में बने थे ये. The rule was called as Indian Railways Public Relation Department in bracket Group A and Group B Post Recruitment Rules 1982, जिसके अंडर ये PRO का कैडर क्रिएट किया गया था. Soon after, in 1989, Your Lordship, what happened is, due to certain reasons, and the reason I'll cite later, due to certain reason, senior PRO की पोस्ट डी कैडर कर दी गई PR डिपार्टमेंट में. I beg your pardon, कमर्शियल डिपार्टमेंट में. मतलब जितनी 8 पोस्ट थी सीनियर PRO की, उसको यहां से डी कैडर करके इन कैडर कर दी गई कमर्शियल डिपार्टमेंट में. मतलब सीनियर PRO में देयर वाज ओनली 1 पोस्ट रिमेनिंग नाउ.
8 पोस्ट थे सीनियर PRO.
8 पोस्ट थे सीनियर PRO के. उनको डी कैडर करके TT एंड CD एज इन कमर्शियल डिपार्टमेंट में इन कैडर कर दी गई. So 8 minus 7, the senior PRO post was remaining with only 1 post.
How 1 post यदि पूरा डिकार्डर कर दिया था?
Your Lordship, the reason was क्योंकि PRO का काम ये रहता है कि in general language, Your Lordship, what PRO does is he is a bridge between general public and the railway administration. तो 1 post was sufficient. इसलिए इसको decadre करके commercial department को दिया गया क्योंकि revenue.
1 post all India.
All over India. For the southern railways, you have to keep 1 post. बाकी आप अपना कर सकते हैं, but for southern railways, keep 1 post and rest can be done. Union of India challenged it before the Honorable Apex Court. Apex Court upheld that for the southern railways, they have to keep 1 post. So now senior PRO remained with 2 posts after the Honorable Apex Court judgment. 8 में से 7 बची थी. Apex Court के judgment के बाद अब 2 पोस्ट बची. I beg your pardon. 8 में से 1 बची थी पहले. Honorable Apex Court के judgment के बाद अब 2 पोस्ट बची. Later on, 1 more post was created when the metro railways were introduced. So now, at present, there are only 3 posts for the senior PRO.
First question was put to you whether ad hoc is allowed in the rules.
Your Lordship, to promote the
either promote or not promote.
Your Lordship, चूंकि PRO से senior
so
PRO
1947 joined.
1997, Your Lordship.
97.
Sorry.
14/7, 1997 he joined.
97 joined.
Yes, Your Lordship. And
promoted after
In 2004.
17 years almost.
17 years.
yes.
हाँ
Yes.
हाँ ये तो है. ad hoc में भी promote किए. ad hoc मतलब होता क्या? ad hoc whether allowed.
Regularized नहीं किए थे इनको.
You cannot leave any point. You are being watched by someone.
Your Lordship. Your Lordship. The third ground is delay, Your Lordship.
क्या?
Is delay.
Delay.
Is delay.
Delay will नहीं लगता इसमें.
Delay. Why, Your Lordship? Because he was appointed in 1997. The whole construct.
उनको promote cause of action is continuous.
He
How
could
the
have.
proposition of delay, if the right is created under the rules which is a statutory effect, the
Your
cause of action still he is not considered, it is continuous.
Your Lordship, but it started.
As per Annexure R2, dated 4/5/1989. It is further submitted that though these rules were subject of deliberation before the CAT Madras and subsequently before the Honorable Supreme Court. But wherein 1 post was created, only 1 post was created for the Southern Railway. Consequently, that cannot be made applicable and claimed the respondent cannot claim a parity. To claim the post in the Southeastern Railway. He placed his reliance in 1999 5 SCC 138 to submit that. In the likewise situation, the number of posts could have been reduced as the rule itself provides, gives the lever, and the posts were decarded, whereby government has exercised its discretion to achieve the object. When the policy has been declared for filling of the post, it has accordingly been made. Consequently, the finding of the learned tribunal CAT is faulty, which needs to be interfered. Per contra, learned counsel for the respondent would submit the issue of interpretation of rule of 1982 came before the CAT Madras and subsequently traveled to the Supreme Court. The Supreme Court in its judgment has interpreted the same to hold that the administrative instruction cannot be supplant the statutory rules, the rules which has a statutory effect, interpreting the rules of 1982. It is further submitted that 45/1989 to decard the number of posts was not within the administrative domain, as the rules was tried to be transgressed. Communication of 49589, the respondent was conscious of the fact to amend the rules and accordingly instruction was issued. Therefore, the judgment of the learned CAT, which is further been followed in the case at Calcutta, at the CAT Calcutta, na?
Followed.
Calcutta and
Jaipur.
Jaipur. The similar proposition was found. We have heard the learned counsel for the parties. In the notifications made subsequently, it shows that in respect of public relation officer, 23 posts were created in the cadre, and for senior public relation officer, 8 posts were in the cadre, and for chief public relation officer, 9 posts were created. These posts were decarded by the order dated 4/5/1989, administrative order dated 4/5/1989. This issue came up before the Honorable Supreme Court in the matter of Swan, in the matter of Union of India versus M. Samagumam, has reproduced the submission made. Reading of the said submission would show the court held the finding of the tribunal to hold decision taken on administrative side to violate the existing rules governing the cadre and of senior public relation officer. Are required to be decadre is to be made. The necessary amendment is required to be carried out. Instructions. The instruction cannot rule contrary to the rules. Even otherwise, if the judgment, if the same Next thing. The other aspect of the issue is that even if the similar rules have been interpreted by the Supreme Court, and the validity of the rules have been upheld over the executive instructions, the railway being this one and same, it cannot be applied in part and piecemeal. It cannot be said that the judgment will only confine its territory to the Southern Railway, out of which the matter went up to the apex court. This judgment would be, the interpretation of the rule would be a judgment in rem for the purpose of the judgment in rem, as no adverse finding can be arrived at to interpret it otherwise. There cannot be hiding of spot when it has already been deliberated by the Honorable Supreme Court. Consequently, the order of the cat, which we find that it is in parallel and narrative have been correctly been pushed on the dictum of the Supreme Court, no fault can be attached to interfere with the order accordingly.
Your Lordship, I was
Petition.
not intending